MSW Media.
I signed an order appointing Jack Smith.
And nobody knows you.
And those who say Jack is a fanatic.
Mr. Smith is a veteran career prosecutor.
Wait, what law have I broken?
The events leading up to and on January 6th, classified documents and other presidential records.
You understand what prison is?
Send me to jail.
Hey, everybody. Welcome to episode 44 of Jack, the podcast about all things special counsel. It is Sunday, October 1st, and I'm Allison Gill.
And I'm Andy McCabe. Hey, Allison. It is October, and it's spooky season, not just because Halloween is on its way, but also because Trump's court calendar is getting scary. Yes. Ooh. It's piling up, and it's looking worse by the minute. We have a lot of news to get through today, including Judge Eileen Cannon granting, in part, Jack Smith's motions for conflict of interest hearings. We have some briefings regarding Walt Nauta getting access to classified materials, and Jack Smith opposing a 3-month CIPA delay requested by, you know who, Donald Trump.
We knew it was coming. Yeah. And we have all kinds of filings and responses and hearings and rulings in the D.C. espionage and obstruction case with Judge Chutkan, including her well-reasoned denial of Trump's motion to recuse. We were waiting for this.
That's right.
We have a date set for a hearing about the narrowly tailored order restricting Trump's extrajudicial statements. Some people call it a gag order.
No,
We don't
call it a gag order.
Don't call it a gag order. The half gag. And Trump asking for CIPA and pretrial motion delays in the D.C. case. He's asking for CIPA delays in the D.C. case, not the actual, classified documents case.
Yeah, I think it's a matter of time before he requests CIPA delays in the Fulton County case as well. Why not? Just throw it out there.
He's going to be up at the New York Attorney General's office Monday like, CIPA, it's too fast. Stop it. That's his only defense is delay.
That's right.
Then we have a couple stories about Trump's legal team, the applicability of 1512, like Title 18, Section 1512, obstructing an official proceeding. Then we will field a listener question or two. So I'm excited about that. And if you have any questions that come up during the show, there'll be a link in the show notes for you to submit that question. All right. Andrew, where should we start today?
All right, let's go to D.C., where our folks will remember, of course, that a few weeks ago, Trump's team filed a motion requesting that Judge Chutkan recuse herself from the trial. And basically the reasoning was that she had made statements in other January 6th defendants' cases. And those statements vaguely referred to Trump and the fact that he had not been charged yet. And they said that based on those statements, there's no way the public could possibly have confidence in her being unbiased in her treatment of Trump. Now, of course, Judge Chutkan rejected that request officially this week, and she issued an order in doing so. And of course, in that order, she says that her statements were not influenced by extrajudicial considerations like, things she'd seen in the news and stuff like that. Instead,
because that was this whole thing, right? You watch the news, you clearly hate Donald. You have to recuse yourself. And she's like, these statements, which you and I discussed pretty clearly, were responses to sentencing, memoranda from just two out of the 300 million people who've been sentenced for January 6th. These were statements they made in their sentencing memos that she had to address because that's her job, right?
That's exactly right. So those defendants, when they were putting their package together, kind of requesting, as much leniency as they could get in their sentence, one of the things they pointed out was, it's not fair that I've been convicted for this offense and the guy who I was doing it on behalf of, Donald Trump, hasn't even been charged. So she was really obligated to address those arguments in her order of what sentence that defendant would receive. And so anything done in the course of that proceeding isn't really ever considered on recusal in consideration of a recusal request, because the judge is obligated to talk about those things and indicate their opinion. That's their job, right? They listen to what you know. They know what you've been convicted of. They listen to how you make an argument as to how you feel you should be sentenced, and then they have to make an opinion and ultimately a ruling.
They have to do that, right? Like if I'm being sentenced for whatever, and I put in my sentencing memorandum, like, you know what? I'm blonde. I'm 5'8". I don't deserve to be in jail, right? She has to be like, hey, you're blonde and 5'8", and this is your reasoning for not being in jail. Here's why that doesn't work. It's not my job to determine that you're 5'8". It's not my job to determine that you're blonde.
Here's why that's not relevant.
Looking at you, we can see that, but yeah, it's not relevant. And then for me to come back and say, look, she put me in jail because I'm blonde and 5'8" is not an argument.
It's even worse than that. It would be like the next defendant in a totally different case saying, you should recuse because I am also blonde and 5'8", and clearly you don't like.
True, this isn't even
blondes.
my appeal.
Yeah.
It's somebody else's appeal who hasn't even gone to jail. Okay, you're totally right. Yeah. Now I'm actually. I thought it was ridiculous. Now it's like extra.
It's turbo ridiculous. Yeah. So that's
turbo
basically
extrajudicial ridiculous.
Right. That's basically what she said. No, I'm not going anywhere. So let's look at this holistically. The whole motion to recuse, massive swing and a miss. And in addition to not getting it, they still have her as their judge, and now she's probably not real happy with them because they've accused her on the record of being biased and essentially incompetent to, not properly seeing these proceedings through. So not the best footing to start on.
Yeah, I feel like they're just like poking her, like, hey, we should execute the ex-joint chiefs of staff, and we should shut down the whole media and treason and hang everyone. And, oh, I'm sorry, do we want to have a hearing about my extrajudicial statements trying to influence the jury? Okay, cool. Like, it just seems like at this point, and you and I have talked about this, like, why would he do this? Why would anybody be such a horrible person to the judge presiding over the case that you're about to go to trial for?
Yeah.
And the only thing I can think of is just to prod her into maybe issuing a partial gag order or narrowly tailoring his extrajudicial statements so that he has something more to cry about.
Yeah, I think that's right. I think any normal litigant in a criminal or civil matter would never do this. You would come up with strategies and you'd raise issues you thought were legitimate, but you would also raise them in a way that didn't prejudice the judge against you, didn't insult them, didn't call them biased, because you know that they're going to have to make decisions that will impact you. This is like a slash and burn litigation style. It's almost like they've already decided there's no way they can win on the merits. There's no legitimate defense here. So what they're going to do is one Hail Mary pass after another at trying to create an issue they could file an appeal on after conviction. And in the course of doing that, file all these motions and then appeal all the results of these motions and delay. That's it. It's like burn it down. And if you can't burn it down, make it last longer. That's their whole strategy.
Scorched earth, right?
Yeah.
Also, Trump here's his other defense, delay. Right? That's his only other defense. And he's doing this in the DC case. He's filing a motion to delay for CIPA considerations in the DC case. Now, we know the DC case has about 300 pages, maybe 10 documents that are classified. These documents are not going to be used in their case in chief, which is the case in chief is the case that the prosecution puts on.
Right.
They may be used in defense. They may be Jenks material. They may be Brady material, right?
Sure.
They might be something that the defense needs to have, by the law. So there's very little classified documents, not like Mar-a-Lago at least, where there's about 3,500 pages, about 300 documents. Now, he filed a motion to delay CIPA considerations in Judge Chutkan's court. And this is right after she ruled that she's not recusing herself. Bam, bam, we get these two motions, the CIPA motion for delay, and he needs more time to file his pretrial motions, like his motion to dismiss the whole case based on whatever. But he wants like a lot more time to file these things. That's not going to jive with the court schedule. And Judge Chutkan has put out a minute order, what's called a minute order on the docket, where she says, okay, Department of Justice, I need you to respond to these requests for delay, and I need you to do that by October 3rd, right, which is a couple days from now. So next time you and I get together, we will have the Department of Justice's response to his motions for delaying the DC trial for these considerations.
That's right. And this is yet another hand grenade of delay. He's going to keep tossing these into the proceeding to try to create nonsense. The pretrial motions that he's required to file and now apparently needs more time to handle. This is normal stuff that kind of, administrivia of getting ready to go to trial in a criminal case. Motion to dismiss. You might make a motion to protect a certain witness or person from having to testify, or you might bring a privilege issue or something like that. Try an effort to keep some testimony out.
I think he wants to file a motion to dismiss based on selective prosecution.
Right.
Right. Which means you're only doing this because
not fair.
Donald. Right. It's political prosecution.
Right.
He does this. And the thing is that I guarantee you Jack Smith has his response ready. It's filed
already. Right. It's based 100%. It's based on the fact that he's actually the, 1,000th person charged with offenses related to January 6th. So I'm not sure how that selectivity.
I can't wait for that argument. We have 1,112 people that we've tried and convicted. You're 1,113, and we've got about right now 286 behind you, and more to come. Sorry, not to be I know this is going to make you sad, but you're really just one in a few thousand people. But
it's not. But I'm the leading candidate for the Republican Party for president. That will be his argument. He'll say, "Oh, it's all political. It's Joe Biden. He's doing this to me." But in any case, we'll tear through that when it comes out. Right now, we're trying to sort through the latest motions for delay. And as you said, the judge has scheduled a hearing on October 16th to have a hearing on the government's prior request to issue the don't call it a gag order on Trump over his extrajudicial statements. This is kind of interesting because we got some reporting really in the last day, I guess, that in an additional filing on Friday, the government is now rolling into their request for this gag order Trump's recent postings, those things that he posted in the last week or so, specifically referencing the postings regarding now retired General Mark Milley, who was the chairman of the Joint Chiefs of Staff, who his
speech, by the way, his retirement speech. Wow. He was I take an oath to a constitution, not to a king, not to a queen. I take an oath not to a person. And then he goes, not to a dictator, not to a wannabe dictator. He specifically.
I wonder who he meant with that.
He was totally just talking about, Biden, right?
No.
Wow. He was very pointed and he's very mad. And I'm wondering if now that the uniform is off, if the gloves also don't come off.
Yeah, he poked the wrong bear because this one has got a bite. Of course, Trump had tweeted earlier in the week, made some crazy accusation against Milley and said he had committed treason and, I don't know, should be put to death or acknowledged that the penalty for that would be death. Now, the reason this is relevant to us, even though, it's just normal disgusting behavior by the former president. But what makes it relevant to this show is, as the Jack Smith team pointed out, he is basically threatening an identified potential witness. In this case, Milley is potentially a witness. The government has already indicated that to the defense. And now you have Trump both making a comment that could threaten the witness to try to, force the witness not to testify, but also could prejudice the jury pool against that witness. Going out and telling however million people heard him that Milley, accusing him of treason, that's certainly something that could make and it could make witness or jurors could prejudice their perception of Milley if in fact he testifies.
Yeah. And Milley on 60 Minutes was like, yep, I've got security. My family has security. He doesn't seem afraid of this particular person's, Donald Trump's, screeds about go get him. I mean, basically, he's like, Mark Milley is a traitor. Yeah. Get him. Right. Like, I mean, that's what he's saying. So it's really, it's scary and dangerous, but also he's like, I'm ready. Bring it. I'm Mark Milley. So
it's crazy, right? You think about, why does Trump do this? Well, it's just his normal vindictive, small-minded, moronic comments. Certainly not even the first time he said this. He said it about Comey and I a couple of years ago, that we're guilty of treason and should be put to death. So maybe it's just that. But here's my proposal is, it's actually more than that. I think this is, again, part of his warped litigation strategy. He's going to keep, if you draw a line in the sand, he's going to step over it. If you draw another one, he'll step over that one. And the reason he's trying to push the judge into actually instigating, or I shouldn't say instigating, to placing a gag order in some respect on him in this case, and thereby creating a massive First Amendment issue that could potentially make its way to the Supreme Court. This is a provocative effort to create an issue he can take to the Supreme Court.
Yep. And I wonder, like, how many days away are we from him saying, how terrible would it be for one juror who loves Donald Trump to show up and lie to on the jury questionnaire? That would be awful. It would mean that, we're going in a wrong direction. But how terrible would it be for someone to show up and lie on their application so that they could be a juror to save Donald Trump? How terrible. That would be bad. We're days away from that
recruiting the candidate. Yep. I think you're absolutely right. So the Jack Smith team is in a really tight spot here. They have to kind of calculate.
So's the judge,
right? What's worse? Do nothing and let the kind of level of offense that is taking place right now through his public communications continue to escalate? How bad does that get? Or do you take the risk of requesting the gag order, or on the judge's part, putting it in place and creating an issue that could, A, really slow down this trial, and B, push something to the Supreme Court in the event that, the conviction does not go Trump's way? So they're, once again, having to make some really careful tactical decisions, both principled decisions, but also not without tactical implications.
Yeah. And his whole, by the way, another response that Donald Trump submitted, or his lawyer submitted on his behalf, in opposition to a narrowly tailored restriction on his pre-trial extrajudicial statements. Every time I have to say it, it's like so many words. He filed he put another filing in. President Trump, that's he refers to himself. Right. President Trump respectfully submits this response in opposition to the prosecution's motion to impose unconstitutional prior restraints on President Trump's political speech. Like, twice they put President Trump in a sentence. And then the motion they put. And so he just goes off this whole thing. We've read, it's 25 pages. We've read a million of these now, and I'm not going to go into this again. But it's the same filing. It's like, you're trying to trample on First Amendment, free speech, America, what the hell? You know, I mean, it's just the same dumb
Yeah,
kind
it's
of
like a grievance
argument over and
a
over
grievance
again.
argument. Like, I'm the only one between you and the government removing your
Wrapped
right
in a
to free
campaign
speech.
statement.
Yeah,
right?
for
Yeah.
sure.
If they do it to me, they'll do it to every American. Yeah, it's
Yeah.
the same filing that we've seen a million times. So
Right. Absolutely
Yep.
not the first time someone has been admonished by a judge to not engage in witness tampering. I mean, come on. That's basically what we're talking
first
about.
presidential candidate, though.
Right. Yeah. Okay. So what? Right.
I
And-
know. I'm just
Yeah.
throwing that in there.
And I
you know,
mean,
it's-
witness, I think, you're going to see some in her, ultimately, whatever she rules, reference the fact that witness tampering is not protected speech. It's kind of
Yeah,
like
I'm
defamation
sorry.
or something.
You can't call for the death of witnesses in this
No,
case.
no.
Like Fredo, like hi, like what? I can't.
Yeah.
The fact that this is even a thing, it really is kind of pushing the bounds of the judicial system to a place
No
it's never
question.
been before.
And that's his deal, right? He puts pressure on things to break them, whether it's DOJ or the FBI or the judicial system or just something that he sees as an obstruction or to what he wants to accomplish. So that's what he's trying to do now. He knows his only way out of this is to literally break the system, and that's what he's trying to do.
You have some personal experience with that, Andy?
Oh,
That, man,
just a little. Just a little.
Man, oh man. All right. So Judge Chutkan has scheduled the October 16th hearing for his extrajudicial pretrial statements order. That's that's like a couple of weeks away. So we'll report on that for you. I think we might have some friends in the courtroom who can actually maybe come on the show. Let's see if we can give them a call.
That'd be great.
I would love to know what it's like in that courtroom when that hearing happens. His appearance, by the way, Donald Trump's appearance is waived. She does this for every single thing so that he can't delay it. Like, I have 17 other trials that day. I need more time.
I'm getting
So
my
she's
hair
just-
cut that day. I can't be there.
No, you're not. So she's just waiving everything. She's like, you don't have to be there, okay, fella? Just send your lawyers.
Yeah, and it's also, I'm sure she's thinking like, I'm going to waive it every time I can, so he can't come in later and file some crazy motion saying it's not fair. You're impeding my campaign, because will have had a record of basically conceding to his
It's up to
choice
you.
of convenience. That's right.
Yep. Up to you, buddy.
That's right.
You come or not, right? That's exactly what I would be doing as well. So I appreciate that. All right, we have a lot more to get to, but we have to take a quick break. So everybody, stick around. We'll be right back.
Welcome back. Okay, let's head down to Florida, where Judge Cannon finally grants the DOJ motion for Garcia hearings. So these are, of course, we've talked about these a couple times. These are the conflict of interest hearings that the government requested the judge engage in, having pointed out the seemingly obvious conflicts of interest presented by attorney John Irving. First of all, John Irving, who represents Carlos de Oliveira and some other witnesses, and also Stanley Woodward, who used to represent Yuscil Tavares and still represents Walt Nauta. So you have some very clear...
and everyone else. Like that guy...
Right. Woodward, yeah.
Like he puts on his running shoes every time he goes to court because
Yeah.
he's back and forth to like 3 different courtrooms representing January 6th defendants, representing Trump defendants. He's all over the place.
So there's a minefield of potential conflicts, but at least one comes into clear focus on each of them. De Oliveira and Nauta now stand to be basically accused by people like Tavares and others, and the prior representations are a problem because Stan Woodward can't accurately represent Nauta if Tavares takes the stand against Nauta, things like that. So,
But if Tavares waives his conflict of interest and says, you know what, I'm not worried about being cross-examined by my former attorney who told me to lie. By the way, that's just the told me to lie part, that's me speculating.
Right.
I just went. He might have said, like, say you don't recall, like Passantino did with Cassidy Hutchinson, but that seems to be the go-to. Hey, you don't recall stuff that you actually recall, but we don't have proof of that. But he might waive his.
It's
conflict.
possible, but both of them have to waive it, right? Because each of them has a potential problem with Stan Woodward having represented the other one. They each stand to lose.
That's why Jack Smith wanted alternate counsel at this hearing to advise everybody.
Right.
So that an alternate lawyer, like they had up in Judge Boasberg's court when they appointed a public defender to Tavares, they wanted some alternates down here so they could say, hey, by the way, Nauta, De Oliveira, here's the problem for you.
Right.
If Woodward is still your lawyer or if John Irving is still your lawyer. But the judge denied that.
Right. So it would be a practical and complete thing to do to have those alternate counsels there to advise these guys, to explain to them exactly what the potential conflict is and the impact of it. You don't want Woodward explaining that because he's the guy that's conflicted.
No, I'm great. So, you trust me. Come on,
so
hug,
there's a clear judicial economy reason for having them there. But also, let's be perfectly fair, it's a little bit of a tactical move by the prosecution, right? Because they know that if you get an actually independent kind of neutral counsel to advise these guys, it's possible you might split one or two of them off as cooperators, as happened
like
with
you did with
Tavares. That's right. So
exactly.
Everybody's working it here. Of course, Cannon's decision went really against both logic and what might have been helpful for the prosecution. So she's going to have the hearing. Again, here she is splitting the baby in an illogical way. I'm going to have the hearing, but I'm not going to have the lawyers there who could actually make sure that it's done completely in a voluntary and intelligent way. So,
or witnesses. She's like, I don't want to hear your evidence. Let's have a hearing, but I don't want to hear your evidence is basically what she said. No.
I don't need any facts for this. Just let's talk about it.
Just get in front of me. Yeah.
I doubt she's going to rule from the bench too. Like, the result of this hearing is going to be, okay, let me think about it another few
month
weeks.
or two out.
Yeah.
That's what she's doing. And this seems to be her MO so far, like not making any overt, horrible rulings that could be overturned by the 11th Circuit, but just taking a long time. Took her 3 months.
Right.
To get that protective order for classified information out. Dude, it seems really obvious to me. She's nickel and diming delay on this, but there's not much you can do about that. And we already sort of suspected that this trial wasn't going to take place in May. It's going to be well after the next election. So she granted those motions in part, granted the hearings. Those hearings, both of them are on the same day for Irving and Woodward, De Oliveira and the other witnesses. That is October 12th. One is I think at 11 in the morning, one's at 1 in the afternoon. And she's like, so yeah, split the baby. Like you said, no witnesses. I don't want any evidence. No standby lawyers. I'm not Judge Boasberg. Yeah, you definitely aren't Judge Boasberg.
She's a conundrum. I mean, you kind of walk away from each of these decisions trying to draw the line. Is this an actual effort to delay things and help out the defendant? Or is just she's doesn't really appreciate the importance of moving this forward quickly? Does she not appreciate the significance of having alternative counsel there to do what we just talked about? So that old kind of bias or incompetence balance is you never quite get it resolved with her.
Nope, that's very true. Also, September 25th, the Department of Justice and lawyers for Walt Nauta filed about 30 pages of supplemental briefs because Walt Nauta's like, hey, I was in the Navy. I should be able to look at classified stuff.
Sure.
And the DOJ is like, no, bro, you're not being charged with espionage.
I've seen
under
all the Mission
Espionage
Impossible
Act.
movies. I think I should be able to see classified now because
I'm friends with Andy McCabe, so I
You're
stood
definitely
within
not getting access to classified for that
I
one.
stood within 5 feet of the former director of the FBI one time, so I should I should be able to see everything. So the DOJ and lawyers for Nauta, about 30 pages of supplemental briefs. Judge Cannon asked for these briefs after a closed hearing, a sealed hearing on September 12th. It is now September 30th. So here's the filings 2 weeks later. Now, DOJ has produced classified documents to Nauta's lawyer, but has opposed Nauta seeing them. Like he doesn't need any of this. Okay, he can see the one document that he saw in that room of spilled boxes when we, the photos that we got and the indictment of the spilled boxes that somebody took. Okay, he can see that one. But the other ones he doesn't need to see. He's not charged with retention of national defense information. He's charged with obstructing moving boxes. He doesn't need to see any of what's in the boxes. And this is common, by the way, in CIPA cases for somebody to want to see and then be, have that objected by the government. But as Roger Parloff points out, there's no 11th Circuit precedent here because most CIPA cases happen in Virginia and D.C. and New York, right?
Yep.
Where the CIA headquarters is in Virginia.
That's right.
D.C. because that's where all the classified information kind of lives. Now, the Department of Justice argued Nauta doesn't need to see them, like I said, because he's not charged under Espionage Act, but it appears Cannon finds this a very difficult issue to rule on. So both sides have submitted briefs 2 weeks after a hearing, a sealed hearing. But yeah, which again, seems like this is all slow roll. And then Jack Smith has filed his opposition to Trump's motion to delay CIPA Section 4. And Trump has said, I need 3 extra months for this. And Jack Smith is like, no, you absolutely don't. That will throw the whole schedule into chaos. Quote, in light of brief delays in the entry of CIPA Section 3 protective orders, which is the protective order we just got after months, and defense counsel read-ins to certain compartments, the court invited the defendants to file a motion to extend deadlines related to CIPA Section 4. Hey, it took me 3 months, right, to decide on Section 3. So
right.
You get an extra couple, you get a little more time in Section 4. Instead, Defendant Trump, joined by his co-defendants, filed a motion that threatens to upend the entire schedule established by the court and that amounts to a motion to continue the May 20th, 2024 trial date. Defendants argue for a schedule that would delay even the initiation of CIPA Section 4 proceedings by over 3 months. And here's the problem. By doing that, Trump, number one, misstates what's necessary to file an ex parte submission setting forth general defense theories, which he should have had since 2 years ago.
Mm-hmm.
Number two, falsely accused the government of delaying discovery. He did that in this filing. You delayed discovery. No, CIPA Section 3 took a minute to...
Who is this CIPA that you keep talking about? I don't know.
I don't like her hair. He doesn't even know what he's talking about.
I think CIPA is biased against me.
CIPA's totally biased. Yeah. I don't like her. Number three, unnecessarily proposing overhauling the CIPA schedule, including by implementing responsive non-ex parte Section 4 briefings, even though that approach is foreclosed by the 11th Circuit's decision. And I love how every time Jack Smith gets a chance to throw the 11th Circuit precedent in here, like, hey, everybody,
I mean,
just want
he
you
knows
to know.
that is one of the few things he can do to get this judge's attention. Okay, your overseers in your backyard have already weighed in on this novel concept of precedent. Okay, we're going to point it out to you.
Yeah, and then also make arguments about prudential searches and discovery obligations that are not relevant to deciding this motion. He did that, overstating the complexity of pretrial discovery litigation and meritless. All of this is meritless in any event,
right.
The DOJ says.
Right.
Current CIPA schedule should proceed apace. And, for the foregoing reasons in his conclusion, if the court's inclined to grant an extension, he says, for the defendant's ex parte filing because of the 3 months that she took to decide CIPA Section 3, because remember we talked to Brian Greer who said you have to decide Section 3 before Section 4 and Section 4 before Section 5. It's like a funnel. It has to go in order. And so he's like, look, if you need to grant some time because Section 3 took so long for no good reason,
Yeah. Give him a couple
go
days.
ahead. He says it should be no longer than about a week. He actually puts in a filing about a week. This is the DOJ. And the other dates in the court schedule order should be maintained. So he's like, 3 months? No. You can delay it like a week. That's all you need.
So again, here's another case. Really, all we're litigating is delay. And the judge here, she makes your head want to explode. This whole idea of like, you have an issue, you've got a motion, you do the hearing, and then later after the hearing, you request briefing, which then takes more time. Compare that to how it's done in DC. Judge Chutkan gets a motion. She very quickly says, okay, fine, government, I need your response by this day.
October 3rd.
Yeah, and then we'll have a hearing the next day, and then I give you my ruling the day after that. Like, that's how you move things along. It's typically considered beneficial to have the briefings, the papers before you get together in court to discuss something. Just for that reason, it makes it quicker. But yeah, there's no sense of urgency here.
And Andy, Judge Chutkan, correct me if I'm wrong, is probably way busier than Judge Cannon.
It would seem so. I mean, Judge Cannon is the only judge in her courthouse, right? So I guess maybe she's probably got some other stuff to do because there's no one else there to do it. But the fact that she's the only judge in that courthouse tells you there's not a ton of stuff to do there. She's kind of in a satellite from...
And she's not the only judge in the district. I mean,
no. She's just the only one in that courthouse. It's like think of it as like Fort a satellite Pierce. Office from the main, the center of that district is in Miami, of course. Mm-hmm. Whereas I don't even remember how many judges are on the district court bench in DC. But the simple fact that they've already handled almost 1,000 cases, they've got almost 1,000 January 6 cases, right? So, yeah, there's a pretty active practice in Judge Chutkan's chambers.
Kind of sad out of all those cases that Donald Trump could only find 2 that he found objective, like statements that he objected to for his motion to have her recuse herself, which is just so ridiculous. All right, everybody, we have more to get to, but we have to take another quick break. Stick around. We'll be right back. Hey, everybody. Welcome back. So for a while now, the question about the applicability of Title 18 U.S. Code Section 1512, which long time we've talked about this, that's obstructing an official proceeding, has been winding its way through the courts. The applicability of this law has been winding its way through a court. Several rioters from January 6th have filed motions kind of contesting what the law means. They've contested what intent means, or they've said that since they had nothing of value to gain from obstructing the electoral certification, that they shouldn't be charged with this. And now for the second time, the Department of Justice has asked for an extension to file their briefing, their thoughts on this matter. Currently, their response is due on October 2nd, but they would now like until October 30th, saying that the Department of Justice attorneys responsible for this briefing, quote, have been heavily engaged with the press of previously assigned matters with proximate due dates. Like, we've got a lot going on in this court. Now, the 1512 charge has been used over 300 times. I think 317 to be exact, at least as of this recording, in January 6th riot cases, and 2 times in the Trump coup indictment in D.C., right? 1512K and 1512C2, which is conspiracy to obstruct an official proceeding and obstructing an official proceeding. And we knew that this was coming. I mean, we've talked about it since forever. So they're relying on this particular charge. Now, we'll keep you posted, but you and I, Andy, have talked in previous episodes. I don't think this actually impacts Trump's charge of 1512 because he actually does have something of value to lose.
That's right. It all comes down to that issue of the statute said, I don't have it right in front of me, but the statute basically says if you corruptly perform the following acts. And it's that, so that word corruptly kind of defines what sort of intent you have to have. And
Right.
many of these litigants, these are like lower level people who were in the Capitol, involved in the mayhem, what have you. They're saying, well, we didn't do anything corruptly because we didn't get anything out of it. We didn't receive any like pecuniary benefit from doing
Right.
this.
No money, nothing of value.
We weren't doing it to get a job or to make money or to enrich ourselves or any of that stuff.
We did it because Trump told us to. And
That's right.
We love
That's
that
right.
guy.
So there is an issue there. It's a place that I think could benefit from some appellate court, specification on exactly what corruptly requires. But in the Trump case, he very clearly did what he did for corrupt purposes. He was trying to win the election that he had just lost. He's trying to steal
And he was
the
fundraising
election.
off of it. I mean,
Yeah,
talk
so-
about pecuniary benefits, like
Right. So
a couple $100 million.
Right. So unless a court comes in and basically completely rewrites the statute in some significant way, which could happen, but I think is highly unlikely, I don't think this will have a huge impact on his charges.
Right. Because, I mean, SCOTUS could come in and, like they did with the bribery and corruption law,
Yeah.
and say,
That's right.
you know what? You have to actually walk up to somebody with a bag of money and say, this is for
Yeah.
this act. And the other person has to say, thank you for giving me this money so that I can vote on this legislation.
Right.
They might rewrite 1512C2, but again, like you said, even if they do, it doesn't really impact Trump's charges.
I don't think so. That's right.
It just wouldn't unless they completely take it off the books.
Yeah. They could come in and say, create a very high bar like they did in the McDonald case, saying basically, okay, all you trespassers on the Capitol, in order to be convicted, the government has to prove a quid pro quo, that you received something of benefit in order to do your trespassing. I think that's really unlikely. I think it's more likely the court will come in and say, no, you were there clearly in support of Donald Trump. You did. That's your chosen candidate, your chosen party, whatever. What you did was in conformance with conferring a benefit to your chosen candidate, and therefore that satisfies the corruptly. Those conflicting reasonings would represent kind of the two boundaries of where the court could fall out on it, or really anywhere in the middle. So I think that's what we're likely to get, but it's unlikely to affect the charge in Trump's case.
Yeah, no, I agree. And I think he has some new lawyers, doesn't he? Donald Trump just hired a
Yes.
couple of people. Wow, like I'm kind of proud of him. Like, good job. You found some lawyers.
Maybe they can start doing things on time by now. Oh, no, that's not part of the plan. So we learned from Politico that Trump has added at least 2 veteran attorneys to help him defend these many cases. The first, I'm going to say Emil Bove. I don't know how to pronounce his name. Could be Emil, could be Bove for the last name. But in any case, I'm going to call him Emil Bove, former federal prosecutor who was co-chief of the National Security Unit at the Southern District of New York, or the Manhattan U.S. Attorney's Office. And also Kendra Wharton, a seasoned white-collar defense lawyer with some ties to Capitol Hill. Both of them have signed on to the legal team that's been organized by Trump attorney Todd Blanche. In recent days, Bove actually joined Blanche's firm, which you'll recall Blanche started to conduct the representation of Trump. He was with a different firm that he left in order to become Trump's lawyer, and so he started his own little shop. So Bove has joined that team. Wharton has actually launched her own firm, and that firm is expected to partner with Blanche, according to...
Yeah, if you're going to represent Trump, you have to just start your own firm. No firm is going to touch
None
you.
of your prior lawyer friends want to do it with you, so you have to kind of go out on your own.
Sir, this is a Wendy's. We don't have lawyers for you. Yeah. There's no firm that's going to touch you. So you have to either join Blanche's new firm that he created just to do this, or make your own, which is what Wharton did. That cracks me up.
You imagine that when you're the lawyer and you've received the call from, I don't know, Boris Epstein or something, and you go running into the guy who has the office next to you. You go running there. Hey, Trump wants to hire me to be his lawyer. Come on, let's go do it. And your neighbor is like, hey, dude, I love you, but no, man, I'm not going down that road No,
Yeah.
thank
Oh,
you
you're starting
very
your own
much.
firm? Cool, bro.
Good luck with that. Yeah. Okay. So Bove and Wharton are expected to work on Trump's criminal cases, including the New York criminal case brought by Manhattan District Attorney Alvin Bragg and the federal cases filed by Special Counsel Jack Smith. Trump is also facing a fourth criminal case in Fulton County, Georgia, and has hired separate lawyers, a separate team for that matter.
Yeah, although Rudy's Fulton County attorney just quit him, which is kind of fun.
And sued him.
Oh, no, that's a different one.
that's a different
Costello
one.
sued him.
Costello's
One of his remaining lawyers was like, I'm out. Peace out. So
man.
he's so effed.
Jeez. That's tough times for Rudy. I was shocked, although I shouldn't have been surprised at all, that Costello, Rudy made some really disparaging comments about Costello when he found out that Costello was suing him for the unpaid bill. And they contacted Costello for a comment. He, of course, refused to comment until they told him what Rudy said. And then he proceeded to rip Rudy on the record. So it's really, it's getting ugly up there on Team Rudy or former Team Rudy. Yeah, that sounds
fight. Like they're going to tear each other apart.
It's a
Like, we don't even
schoolyard.
have to-
Yeah,
we don't have to do anything.
We're all standing around him in a circle yelling, fight. Okay. Okay, so Blanche, we know, is also an alumnus of the Manhattan U.S. Attorney's Office, SDNY. And he seems to have emerged now as the architect of Trump's multi-front legal battle. So the new hires kind of further solidify his imprint on some of the most significant criminal cases, right? He appears to really be the quarterback over several of those cases. Now, regarding the other two, people who know them have been commenting. Here's one quote. Emil is an expert in white-collar and CIPA-related litigation, and his trial skills are among the best in the business, Todd Blanche said in a statement referencing the Classified Information Procedures Act, which, of course, we know is the federal law governing the use of classified documents in criminal cases. Blanche continued, "We are thrilled and lucky to have him on our team defending President Trump and all of our other clients."
We're thrilled and lucky to have anybody on our team.
Yeah. I'm thrilled to have another breathing human being with a law degree to do some of this work, because Todd Blanche probably hasn't seen his family in weeks.
Probably not. Yeah, I think he also said, Kendra's a brilliant lawyer. Clients have trusted her for years. This is Kendra Wharton.
Yes.
Starting her own firm. And she's providing the same excellent service to our team that's been her signature for many years. Okay.
That seems like a particularly bland statement, but I don't know.
Yeah, so sit down and get ready to have to say a bunch of shit that you don't want to say to a judge. You're welcome.
Yes.
And good starting your own firm, because you're going to have to fold after this, because you could never be seen in front of those judges again. You just go take the bar exam in a different state after this, because you're never going to be able to look Judge Chutkan in the eye as a serious attorney in any case.
We're going to require that you take positions in court that are not based on fact and likely to prejudice every judge against you. And Chris Keyes weighed in with, and make sure you get a retainer up front.
Yeah,
no,
totally.
I made that up.
$3 million, get it up front. Now, this also coincides. Jack Smith brought on a new person onto his team, Alex Whiting. We've talked about this, his deputy at The Hague. In the Kosovo War Crimes Department, I guess. So it appears now that the DC case may have Whiting as a trial lawyer, because he's trial experienced, right?
Right.
So I think I don't have confirmation of this, Andy, but I think he specifically brought Alex Whiting on for the DC trial, just like he brought David Raskin on. And he brought him on last year, but he hasn't really showed up on any pleadings until just now. But I think Raskin might be one of the head, if not the head trial lawyer down in Florida, because he's really, really good at that. And Brian Greer, who was on, as you know, last week, was like, yeah, that guy, sweet. Love David Raskin. He would be an excellent trial lawyer. So I think we may now also see the DOJ's, team, their prosecution team, sort of gelling.
Yeah, I think so. I don't know Whiting. I'm sure he's a great lawyer. I do know Raskin. Raskin's top drawer. They're on the list of probably top 5 national security lawyers in government. I mean, I don't care who's making it. Raskin makes anybody's top 5 list. He's been around for a long time. He's had a bunch of big cases. the Trump team tried to really kind of smear him at the outset of this case with all those allegations of I don't know, impropriety in conversations that happened around the beginning of the case. None of that seems to have gone anywhere, which is what we all expected. So I agree with you. I think Raskin's probably focused on that one.
Yeah, top 5, number 1, headed to number 1 with a bullet.
There you go.
There you go. I forgot Trump badmouthed him at the onset. This was probably in the winter, like right before the holidays of last year, when Raskin was actually brought onto the team, but he hasn't appeared on too many filings. So we'll see. And again, that's not Jamie Raskin. That's not the congressman. This is David Raskin. He's an attorney.
And back to the Trump lawyers, both have pretty notable experience. Bove, we know, handled matters including the investigation of Guo Wengwei, who was a Steve Bannon ally. He's the guy that owned the boat that Steve Bannon, I think, was arrested on the fraud case.
Post office cops. Yeah.
Yes.
The We Build the Wall guy. Yeah.
That's right. Guo was also indicted earlier this year on fraud charges involving an alleged $1 billion fraud scheme. So in addition to him, Bove also worked on the prosecution of Cesar Sayoc Jr., who you'll remember as, I think, the dude who lived in a van and planned to send bombs through the mail to a whole list of people who he thought were being mean to former
CNN
President
bomber,
Trump.
right? Yeah. Like he had all these stickers on his van. I remember
hated
that
CNN.
guy.
I think some government folks and also media folks. And he took a huge hit on a guilty plea, and I think will be spending the rest of his life in jail, if I remember that one correctly.
Bove was prosecutor on that case.
That's right. That's right.
Wow. Okay.
All right. So there you have it. New legal talent for the Trump team, and they could sorely use it.
Yeah, I'm actually surprised because honestly, this is going to be their last case. I guess they're like, hey, give me like Keys did, like you said, like, hey, give me $5 million. This will be, I'll create my own firm. This will be my last case, but I'll do it for $5 million. Like, I don't get, like, the guy who prosecuted Cesar Sayoc is willing to go out on this limb.
Yeah. It also doesn't mean they'll be around like 5 minutes from now, right? Because people come and go and they say, oh, he's the new lawyer, and then they're gone.
That's
so
true.
but
these are big names.
They are.
We'll see.
They
we'll
are talented people. So that's good for him. But let's see if you can keep him around.
Yeah. All right. We have to take a quick break, but I have a question. I have some questions for you about Scott Hall down in Georgia. I know that's a state case, and we don't cover that here on the Jack podcast, but it might have implications in the federal case. So I want to talk to you about that because I know that you're an expert in these kinds of things. But we have to take a quick break. So everybody, stick around. We'll be right back. All right, everybody, welcome back. So the big news yesterday, I mean, first of all, there were a million different filings. Everybody on Trump Team MAGA lost all of their filing, like all of their bids in court in Georgia. It was a really kind of a hard day to follow all the legal filings that went on this past Friday. But the big story, Scott Hall, who is a bail bondsman, who worked with Sidney Powell to steal some breach some voting machines in Coffee County, very conservative Coffee County. He is flipped and he's cooperating with Fani Willis. And while that's a huge story in Georgia, in the state case, which of course we're going to go over, Pete Chutkan and I'll talk about that on Clean Up on Aisle 45 because that's where we cover Fulton County. But this could have implications in the federal cases, couldn't it? I mean, if you've got a cooperating witness, I imagine that anything he says, and he has to, under his agreement, testify truthfully to everything, which includes a 63-minute phone call to Jeffrey Clark, and includes, I mean, he's got kind of his hands on a lot of stuff that happened in the national federal case, not just Georgia in Coffee County, but if you are going to testify, and I think he's going to be a witness for the state, that can be used in federal court, can't it? I mean, you've seen these kinds of cases before, right? Where you have somebody who's in a state court and also in the federal court system, can you use those statements?
Absolutely. You can use them all day long. So statements made under oath in a judicial proceeding, which these would be if he takes the stand and testifies, are universally admissible in another criminal proceeding or another civil proceeding. It's actually a specific exception to the hearsay rule. It would normally be hearsay, but the hearsay rule basically prohibits testimony that's not direct, right? Testimony that's offered to prove the truth of the matter asserted, but that keeps things out. Like you couldn't take the stand and say, Andrew told me he bought the drugs in my narcotics trial, because that would be hearsay.
Well, even like emails and stuff, but because of exceptions,
there's
right?
many exceptions to hearsay, and one of them explicitly says that testimony in judicial proceedings that was given under oath, essentially that can get admitted. So and I assume he made a recorded statement as well. We haven't heard the statement. Yeah, so
but he made a recorded statement to the state. I am assuming that because that's part of the proceeding, that's also admissible.
Yeah, any statements that he made to investigators or to prosecutors in the course of their investigation, now that he's going to be a witness for them, they have to turn all those statements over to the defense in the Fulton County case, because now that's discoverable. So that the defense can use those other statements, prior statements, to cross-examine him, try to make him look like he's telling different stories. So that's there. How it affects Jack Smith, well, for number one, in the way we just mentioned, whatever comments he makes on the record in the judicial proceeding under oath can be entered in the federal case. But also, oftentimes when someone cooperates, they enter into every time they enter into a cooperation agreement with the prosecutors, right? They say, okay, I will agree to be your witness and I'll be truthful about everything. And in return, you're going to drop some of the charges against me or charge me with lesser things and charges
right,
that
because in this case, he pled guilty to all 5 counts, but they became misdemeanors.
5 misdemeanors. Yeah, that was a good deal for him.
It's a really good deal. He gets 5 years of probation. He doesn't have to go to jail at all. And I mean, I suspect all the other people are like, dang.
5 years probation, 200 hours of community service, all pretty good deal when you were facing a RICO conviction. And let's remember, the case against him probably pretty strong because there's videotape evidence, there's audio evidence of these folks that were involved in the Coffee County thing. So he gets a good deal. Probably a part of that deal, well, I shouldn't say probably, maybe a part of that deal requires him to also cooperate or testify truthfully in other jurisdictions that bring prosecutions based on the same conduct. That is frequently added into a cooperator's deal when you know that there are other jurisdictions that might want to use him as well. So we don't know that yet. I haven't heard that reported. But
when they say like
something.
all proceedings, that could include that. Because we've got sort of a general idea, where they say you have to cooperate in all proceedings related to these crimes. That could mean in other jurisdictions.
They could actually identify it specifically. They could say you must, if requested, you must also cooperate with the prosecutors in the DC Circuit or whatever. Or state prosecutors in Michigan, whatever it might be. I'm just guessing.
Right, because he also, Patrick Byrne, right? When you and I have talked about this national sort of push to breach voting machines, It happened in Antrim County in Michigan. Right. It happened all over the country. And we're like, well, it seems like that's something that Jack Smith should prosecute.
Right.
Because it's on the federal level. That could be included in that, but it also, like you have said, it might be a mop-up case. It might be something that he adds later after Trump is done, so as not to even take a possibility of slowing that case down. Yeah,
and the final consideration is, even if it's not explicitly written into his agreement, the fact that he has an agreement and then takes the stand in the Fulton County case and testifies, if he is later called to testify by the government in Trump's case or a follow-up case, or whatever that might be, he's got a much harder time defending that, right? It's going to be harder to come in and say, plead the fifth, I'm not going to testify because I'm afraid of being prosecuted, when he's already got a cooperation agreement in really the only other jurisdiction that could possibly prosecute him. So all in all, it makes it much more likely that he could, now maybe they don't want him or need him, but he could be a witness in one of the federal cases.
Yeah, and even if not a witness, like just somebody to give you more leads on other cases, because Sidney Powell's having a bad day.
Yeah, and listen, dude is on Team America now, right? So typically when people make that decision, they take the deal, he pleads out, he's there, they kind of take it all the way. Especially, like, this guy's he's not a criminal outside of this context. He's just some dude.
He's a bail bondsman, right?
Yeah, so he's probably someone who's inclined to cooperate anyway. And I really don't think he's going to be the last person you see take a plea in the Fulton case.
No, but he who flips first flips best, right?
That's right.
You get a good deal there. But I wouldn't be surprised if she's sitting around waiting to hand that deal to other people too.
Yep.
All right. So do we have any listener questions? Because, if you have a question for Andy or I or Brian Greer or anybody else who we bring on the show, you can submit that by clicking the link in the show notes. Who do we have this week? Okay,
so this week we have Cosmo. And Cosmo writes in a question that I think really touches on something a lot of people have been thinking about lately. Cosmo says, I always look forward to your new insights every week. I have a question about the argument that conspiracy defendants who separate themselves into an earlier trial help the defense of later defendants. He says he understands how it does give the later defendants a kind of a sneak peek look at the government's case. But he says, I also wonder how any one defendant in a conspiracy can stand trial alone. I would think that the fact that it's a conspiracy would require evidence to be introduced about the actions of other conspirators, but they won't be there to defend themselves. Good question. And you're leaning in the right direction on all this stuff. So let's talk about it a little bit in the context of Fulton County, just because I think that's a little bit easier. Obviously, the government brings a case against 19 people. They want to put that case on one time, so they want to keep everyone together. But in Georgia, you got these really strict speedy trial laws that enable a defendant to basically split themselves off and go early, like within 2 months or something like that. And that's what's happening to Chesbrough and Powell. So that's how a defendant splits themselves off. It's much harder to do in the federal system because even though you have, of course, a federal speedy trial right, it's not defined as clearly as it is in Georgia. And the government can actually push back on your desire to split yourself off and go early. And the judge ultimately makes a decision between the competing interests of speedy trial versus the government's interest in putting on a good case, judicial economy, that sort of stuff. So it's a little more gray. But nevertheless, in a conspiracy case, yes, Cosmo, you're right. The government has to prove the entirety of the conspiracy. And so that requires putting on all of the evidence, whether it's just for 2 defendants in an early trial or for the remaining 17 in the big case. They still have to put all the evidence on. Now, it doesn't matter that in that early trial, the other defendants aren't there to, quote unquote, defend themselves. That's just not a factor. The government has that evidence. The fact that the evidence, by putting it out there in the public sphere, could have create negative impressions in the public about these defendants who will come later. That's just part of what happens in a trial. There's no specific rule or constitutional principle that prohibits that. So yeah, all the evidence would get put on in both trials. The later defendants have the benefit of getting that sneak peek and seeing how the government puts on their case. But they also have the downside that you've pointed out, that people have now really heard their names being dragged through the mud.
Yeah, it kind of helps them set up. That's why people have those joint defense agreements, right? Because everybody can hear and get information from lawyers and hearings and stuff like that before a trial even starts. But yeah, in this one, and we just saw the hearing about some pretrial stuff in Georgia, and Judge McAfee, who honestly, so far seems like a pretty decent jurist.
Yeah, doing a fine job down there, I think.
Yeah, he by the way denied every single motion, Jeff Clark's motion to remove the electors' motion to remove, denied the people trying to dismiss their cases based on bullshit. Like he's like, no.
Right.
But he agreed that this trial is going to take 4 to 5 months just for Sidney and the Cheese, right?
Yeah.
Sidney Powell and Kenneth Chesebro. Who, by the way, I asked Anna Bauer. I guess it's pronounced Chesbro.
No, come on. Don't take
but
my cheese
his
away.
nickname, yeah, I know. Don't take my cheese. His nickname is the Cheese. So
have that. I'm good with that. The cheese man.
He's from Wisconsin. So the Cheese. But it, that just for the two of them is going to take 4 or 5 months because, again, like you said, the prosecution, the state has to put on the entire RICO case for just these two. And there are still, I think I heard in the hearing 6 people who haven't filed either to sever or for speedy trial. And by the way, one of my favorite new things, apparently they call these trials speedies. down in Georgia, because he's like, look, yes, it's going to be in courtroom 5A. I'm pretty sure that we'll be done. We have a couple other speedies that we're doing. Like he calls them speedies, which is just
speedies.
It cracks me up. But yeah, 4 or 5 months for the entire thing to be put on. So for just 2 people, and that is probably about how long the other trial for however many people are left that don't flip and plead.
Yeah.
And
remember,
case.
That one is the state case. It's going to be on TV.
Yep, it's
so
all televised.
And
Trump has decided he said, I'm not going to try to remove this to federal court.
Yeah, I think that was a predictable, actually a good move on their part. Don't waste time. You're not going to get it anyway. All those motions got denied. He had a weaker case for that, I think, that certainly than Meadows and maybe even than Clark or others, and wasn't worth the danger of having to take the stand and testify, expose himself like that. So,
and it kind of makes me second guess my wanting the federal trials to be televised, because if Trump wants it, I'm like, I don't know if I want that. Everything Trump wants, if I want it to, it makes me question myself.
Right.
But the cameras are there, and that might to him be a benefit in his mind. I don't know.
Yeah, I think there would be some societal benefit to having the federal cases televised, but it's too late. Like, you can't do this one different than every other federal case. That would just be creating so much room for him to complain and issues.
Yeah, reason to appeal. Right?
So they're kind of stuck with where they are, I think. Anyway, there you go. That's our listener question for the week, and a good one. Thanks, Cosmo.
Yep, there'll be a link in the show notes if anybody wants to submit a question. Thank you so much, Cosmo. That was a great question. And everybody, thank you so much for listening to the Jack podcast. We really appreciate it. Seems like the focus is down in Georgia, but man, there is a lot of important stuff, particularly coming up in October with these hearings in these federal cases. So I look forward to discussing them with you, Andy.
Yeah, absolutely. The pace is only going to pick up on that stuff. So if you really want the deets, the details that go deep on where we are in these cases, this is the right place to do it. Once a week, you get your fill, and then you get ready for next week's craziness.
Yeah, 100%. All right, I've been Allison Gill.
And I'm Andy McCabe.
And we'll see you next week on Jack.